Hello, hello, hello. This is Attorney Mike Gravel coming to you from Chicago. As usual, we've got quite a lineup today. The first one, the one that's on the thumbnail, the worst drug excuse ever, that was sent to me by Ashley. I wanted to thank her. At least she's Ashley over on IG. It's pure gold. It really is. Then we check in with some of our other people. We've Shaq is back. Shaquille O'Neal is back in the house today. Yes, he is. We had to check up with him. Everybody told me about that. Yesterday I had a video called More in Court, and that sent me back on to Simpson's call for a couple of things. I also have an update for old Collier Greens there. And we even do a little visit to our good friend, Aaron Gauthier. Let's get it started, shall we?
All right, Abelardo Nambrana. Oh, he's here. Yes.
Oh, brace yourselves. This is delicious.
Good morning, Your Honor.
Good morning. All right. So there are issues with you. What do you think those issues are?
Thank you for coming out positive on my UA
All right, for what?
for marijuana and coke.
All right, so why are you?
Okay, you're not going to need to hear so much of his responses, but just to lay the foundation, because he's got the mask on, he's there because he flunked a UA for marijuana and coke.
Using?
Okay, I'm not, okay, I stopped smoking weed on July 9th because he told me that I was going to be referred to rehab. And on the coke, I got a woman friend that does crack, and I didn't know that I could get it. When I went to go do a UA, they told me I could get it.
All right, just in case you didn't catch it, he said, I have a woman friend who does crack. Oh, it gets better. Don't worry.
My touch, DNA,
No.
and
No, let's stop. Let's stop with the nonsense. Let's not do that. Here's the thing. I am trying to figure out what your issues are before we go forward with the revocation. So let's stop with the crack, and you're getting it from DNA. So you're telling me from intimate relations is where you're picking up a positive for crack?
Yes, ma'am.
Well, I guess you're going to have to stop intimate relations.
Well, already, when I went to go report this last time, I told her that I had to stay away from her because she's messing me up, and I haven't.
Why would you be dating someone who's addicted to crack cocaine and using it?
I've already known her for 12 years, but I didn't know that it would come
Well,
back to me.
no. Here's the thing. According to your conditions of probation, you're not allowed to be around people who are breaking the law.
Right.
Crack is not legal in Texas.
Okay.
And so your relationship with her is over. If you come before me again with another positive UA and with this nonsense that your UA is positive because of intimate relations, we're going to have an issue. Do you understand?
Yes, Your Honor.
Now,
I love that. Intimate relations. I don't know how she keeps a straight face, but she absolutely gets it all, but maintains this professional judge demeanor while she does it, and it's so enjoyable.
now, when you're tested today, what are the results going to be? Don't make me waste a UA.
I took a UA Friday, so I went and reported to Ms. Santania.
If you're tested today, what are the results going to be? That's my question.
Clean.
All right, we're going to...
And I haven't done nothing. I haven't done no drugs ever since.
And you haven't had any intimate relations with her?
No.
All right, so you're going to get a UA today. You understand? And so you're telling me that UA is going to be negative?
I hope so.
Well, you go from yes to I hope so. What is it? When's the last time you used and what did you use?
I haven't used nothing.
When was the last time you used and what was it?
I haven't used nothing. That time I was with my girl was on her birthday, which was on the 10th.
10th of what?
Of this month.
Mm-hmm.
And I told her that I wouldn't be able to, she's kind of upset because I told her that I wouldn't be able to be with her no more because of the situation that I'm in.
You're telling me she's upset because she can't have intimate relationships with you?
Well,
Thank you, Judge, for professionally saying what we were all thinking. Oh, it's beautiful.
I've known her, like I said, for 12 years already, and she's real attached to me, but I already told her that I wasn't going to go to jail for her or nothing.
And you don't live together, do you?
No, we don't.
All right. So here's the thing, in case you didn't know, because sometimes people don't realize it, you can't be around people who are breaking the law. And if she's using crack cocaine, she's breaking the law. And if you love her, you need to tell her on the phone that there are places for her to help her with her addiction. You understand?
Yes, ma'am.
All right. So we're going to do a UA today. I'm going to see what those results are, and then I'm going to have you come back.
Okay.
Do you need any water?
Do I need any what?
Do you need any water?
No.
Okay. We'll need a UA from Mr. Umbrano.
Yes, Your Honor.
And don't forget to hit like and subscribe, or the dogs get it.
Okay, two things. First of all, I looked and I didn't see him come back because I would have added that appearance, but I just didn't see it. And where are we here? Oh, here we are. Here's our update on all Collier Greens. I did a video yesterday called More in Court. It's fantastic. These aren't as good because he got an attorney, but it's still interesting. And, there were two appearances. I chose the latest one so that, we could be up to date here on Law Talk with Mike. He's got another appearance scheduled, I believe, September 20th.
First case of the people versus Eddie Collier Green.
They call me Tater Salad.
Ashley Longman for the people.
Yeah, good morning, Tom Pietrowski on behalf of Eddie Collier Green on all cases. Eddie, would you identify yourself, please, by stating your name?
Eddie J. Collier Green Jr.
Thank you, sir.
Okay, what are we doing?
I think we're just getting set for a date at this point, Your Honor.
Requesting live exam, Your Honor.
How soon do you want it?
As soon as possible. My client's been in for over 100 days.
That doesn't put the time that he was contesting extradition while in custody in New York.
I was going to mention that. Thank you.
So he's been extradited in? Okay. What the heck? Yeah, that's what I would do. You want this in person? Preliminary examination in person, September 20th, 2022, 9 a.m. That is before me. On all four matters.
With regard to bond, may I address briefly?
Go ahead.
As I've indicated, my client has been incarcerated for over 100 days, and as Ms. Landy has indicated, part of it is his own doing when he fought extradition. Ms. Landy and I did have a chance to at least preliminarily calculate the guidelines. He's 0 to 6 on this 5-year offenses. Bonds are rather healthy. We would be asking for either a personal bond or a low cash bond with no objection to a tether, and certainly we would waive extradition.
Ms. Landy.
Your Honor, we were here last week and defense counsel made the same argument. I recited for the court a portion of one email that the defendant sent to the victim, and the court denied the request. I don't think anything has changed since that time.
I have heard nothing different than the last time the court has heard this bond argument. Further with the issue regarding the extradition and the other issues. Motion for bond reduction is denied. Thank you. Bond will continue.
Thank you, sir.
Your Honor.
Okay.
This hearing both in the courtroom and also online. And we're here in the case of Wodurski v. Rebited for settlement of judgment. And it's file number 21-8891CH. Counsel, would you please state your appearances for the record, beginning with plaintiff?
Dan Martin appearing on behalf of the plaintiffs in this matter, Your Honor.
Good morning, Your Honor. Adol Nucho on behalf of Mr. Rebidic.
Okay, so this is an interesting hearing. I watched the hearing. They're fighting about an easement. I cut all the argument out. It's too boring, and I didn't want to get drug into a 6-hour discussion of easements. But the important thing is they had a settlement at the last hearing. They did not draft an order at the time. They both drafted orders. They have different views of what happened at the settlement conference. The judge chooses one order and enters it. This guy right here who's arguing right now, who makes a nice argument on his behalf, but then goes too far. And the judge is not having it. It's kind of funny to see Judge Gauthier get a little cranky. It's deserved too. I mean, he was totally appropriate, but it's kind of fun to see.
All right, and this is we've had a hearing and on motions for summary disposition, and then you've got proposed judgments from both sides. I guess, Mr. Martin, since you had been the first one to file the, okay. Thank you. I'm going to sign Mr. Martin's judgment of dismissal that was attached to his motion settling the judgment. I understand where Mr. Nucio's coming from, where he would prefer there be a true stipulated judgment signed by all parties. You know, and a lot of times that happens, but when it doesn't, when the parties place an agreement on the record in open court, it is binding. And then if the parties can't really see eye to eye on the little details to sign a stipulation to present to the court, somebody can come to court and say, I just want you to enter it as an order because it's binding. And that's what Mr. Martins does. It says the parties stipulated on the record to dismiss the causes of action. It's for that reason that the court is ordering and adjudging that the claims are dismissed based on a stipulation. The order is not inaccurate. And part of that settlement was the license to use the property for haying for the season being placed on the record in open court during a settlement. That became binding. Mr. Martin's order accomplishes all that. There's no need to say like the legal descriptions of the parties. So I'm signing Mr. Martin's judgment at this time. All right, that'll be the final order closing the case.
Your Honor, may I ask a question just on the record? I want to make it very clear. Are you saying that the court rulings have any effect in the future?
I'm not answering that question, Mr. Nuccio. This is not the first time you wanted to engage in an argument with me about what my ruling is. I heard from both sides, and I've made my ruling. So I've signed an order. The case is closed.
Your Honor, okay. That's fine, Your Honor.
Well, you want to argue with me more about my ruling?
No, Your Honor. I just want, because I just want to make it very clear, if the court rulings are mentioned in that order, my client does want to appeal. And I just want to make that clear for the record.
So it's an order I'm signing a stipulation of the parties. Go ahead. I'm sure the Court of Appeals will dismiss it. And you'll probably have to pay costs. But you do what you do you. But this was a pretty simple dismissal. I've signed a simple dismissal. It says it's on stipulation of the parties. So good luck appealing from that. I wish you the best. Good day.
Okay, so that's really like I said, that attorney made a good argument for his side when they were arguing, but then he went too far. And announcing you're going to appeal to a judge is just pure amateur. It really is. You don't need to announce it. It's not an airport. If you really think you have the merits on your side, you just appeal it. You make the proper record. You think about what you need to get it overturned on appeal. I really don't have a grand opinion as to what it is, because what they're fighting about is what happened in a prior settlement conference that I wasn't party to. So I don't know. But what the judge did seemed eminently reasonable to me. And but if you think it's wrong, just appeal it. But to announce that is very immature. It's very my dad can beat up your dad kind of stuff.
Calls the case of the people versus Shaquille O'Neal Tubbs.
That's right, people. Shaq is back. Let's see what he's doing.
Ashley Lonnie for the people.
Under White on behalf of Shaquille O'Neal Tubbs.
And Your Honor, I do see Mr. Tubbs present.
Yes. Mr. Tubbs, can you state your name?
Yes, sir, Shaquille Tubbs.
Your Honor, the court should be in receipt of a plea form, I really hope.
Yes, I do.
Oh, thank God. Okay. So on that plea form, it indicates the defendant is going to be entering a plea of guilty to an added count 3 of attempted resisting or obstructing an officer, a 1-year misdemeanor, and will also plead to currently charged count 2, which is domestic violence. In exchange for those pleas, count 1, the felony resisting and obstructing will be dismissed. There are no further agreements.
Is that a fair statement, counsel?
Yes, Your Honor.
All right, Mr. Tubbs, can you raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, state your name again for me.
Shaquille Tubbs.
All right. Now, sir, it is this court's understanding that you're going to plead guilty to 2 misdemeanor charges. Is that your understanding?
Yes, sir.
The first is that charge of domestic violence, which is a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. You understand that?
Yes, sir.
The other charge is the added count 3 of attempted resisting and obstructing a police officer. That's also a misdemeanor, punishable by up to 1 year incarceration and or a $1,000 fine plus court cost. You understand that?
Yes, sir.
All right. Understanding all of that, you still wish to plead guilty to these charges?
Yes, sir.
All right. To the charge of domestic violence, how do you plead?
Guilty.
To the charge of attempted resisting and obstructing a police officer, how do you plead?
I plead guilty as well.
All right. Now, you understand that by pleading guilty that you'll not have a trial of any kind.
Yes, that I waive all rights to a trial. Yes, sir.
Yes, you do. And I just have to go through and make sure that you understand. You're not going to have a trial, and you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're also giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent and not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand all of that?
Yes, sir, I do.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead to this charge?
There was no promises.
All right. Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily?
Yes, sir.
Of your own free will?
Yes, sir.
Because you believe that you are indeed guilty of these offenses?
Yes, sir.
May 8th, 2022, at the location of 9006 MacArthur Boulevard, Superior Township, Washtenaw County, State of Michigan. What'd you do on that date involving a LaShawn Rolex bell?
I made
Wait, I didn't catch it the first time. It was LaShawn Rolex Bell. The names are fantastic.
Domestic assault.
Okay, I got that, but that's kind of like a conclusion. You got to tell me what you did.
We were.
Well, first of all, Mr. Tubbs, who is this person to you?
This is my it's my girlfriend.
Okay. And so on that date, Mr. Tubbs, what happened?
She ended up getting into a fight with another female down the street, and I came and I removed her, and we got into an argument.
Okay. And when you two got into an argument, what did you do?
I did nothing but moved her from. I grabbed her and I moved her from down the street.
Okay. So you put your hands on her.
Yeah, I grabbed her.
Okay, but you didn't have her permission to do that, did you?
No.
All right. And when you did that, you didn't do that by accident.
No.
You did that on purpose. Is that correct?
Yes, sir.
All right. At some point, then the police arrived, correct?
Yes, sir.
Okay. What happened with you and the police?
The police asked what happened, and I told them that I don't know what happened. And I pretty much took him on a chase.
Okay, so hold on. So police came to ask you questions. You told them you didn't know.
Yes.
And then you took off running.
Yes, sir.
All right. And you knew they wanted to talk to you and or take you into custody at the time you did that, right?
Yes, sir.
All right. I think that does it. Counsel, if I complied with the court ruling, would it be proper to accept this defendant's plea?
I'm sorry, go ahead.
I'm good.
Defense is satisfied.
All right. Court will accept the defendant's plea of guilty to counts 2 and 3. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be Mr. Tubbs, is anything else holding you right now?
I did want to argue bond, Your Honor. I'm sorry.
I figured this much, but is anything else holding you right this second, Mr. Tubbs?
I got, like I said, I got 2 nonviolent warrants out of the same county up to $1,000 that as soon as I get out of here, I can take care of that. They don't want jail time for me. I've been here for over 30 days, it seems like.
I got you. Okay. Esteban.
Yes, Your Honor. Mr. Tubbs, as he stated, has been in over 30 days. He has now pled to misdemeanor offers. He was picked up on a probation violation, which he said he has taken care of. As he stated, he does have a couple matters outside of this county, which he believes will not come pick him up. So he is asking for a bond, a PR bond on this case.
Response from the people.
Your Honor, I'm not sure whether or not they will come pick him up. I would not be opposed to his bond being changed to a PR once he's met with probation and custody. I'm just concerned that if we lose him to another jurisdiction before he has his probation interview, we may not be able to get that accomplished, and it's going to delay the process of getting him on probation.
Can I say something if you don't mind?
Well, your counsel was winning, so if you want to keep talking, go ahead, because you're probably blowing.
Looks like he sat back.
You sat back? You don't want to say anything now, Mr. Tubbs?
Well done.
Oh, okay, I didn't think so. All right. We'll set his bond at a $10,000 personal recognizance bond. Defendant is to report to community corrections for placement on a GPS tether. All right, but that'd be location tracking only. Okay, you understand that, Mr. Tubbs?
Yes, sir. And
okay. I'll set his sentence. Did I set his sentence?
No.
That's it. Sentencing will be October 12, 2022 at 9 a.m. and that is before me.
And Your Honor, the contact order with the domestic violence victim remains in effect, correct?
Yes, all of that remains in effect, and it's a DV sentence.
Your Honor, I'm not actually
This is going to be a
available.
DV case, so hold on. That sentencing date is incorrect.
Okay.
I'll put him up.
Yes.
I'll put him up now.
So it's October 3rd.
Okay. His sentencing is actually October 3rd, 2022 at 1 p.m.
Thank you.
Thank you, Your Honor.
All right. And he knows he needs to come back because he knows Mr. Tubbs doesn't show up. I'm going to come find him myself. All right.
Yes, sir. Sir,
Okay.
will I be hooked up to that today, right?
Well, they're going to make sure that's got to be, you'll be hooked up to the GPS prior to your release. So they'll get you over there, they'll hook you up, and then you're out on this case. I don't know if something else will hold you.
No.
Okay.
Yeah.
You got it?
Yes, sir. Appreciate you.
It was probably better that you didn't talk for yourself, right?
It was way better.
Yeah, absolutely. You got a good attorney. Thank you, Mr. Tubbs.
Appreciate you.
Thank you, Your Honor.
Court calls the case of the People versus David Polk.
Well, there you have it. We're updated on Shaquille O'Neal, and we're updated on old Collier Greens. Those were ones both those I did prior videos on. It looks like, well, I guess Shaq has got a sentencing, but I doubt anything exciting will happen because now he's pled. You know, Who knows? Who knows? We might have to check on the Shaq sentencing. I haven't decided yet. Collier Greens has got a date on the 20th, but now he's got an attorney. He's not talking. It's not nearly as fun as the mayhem we had in Judge Fink's room. From the video I did yesterday, that was really out there. That was really out there stuff. And of course, for all of those who are late, you really have to go back to the beginning to see Judge Boyd not having any of this horrible drug excuse. I mean, not having any of it, and it was fun to watch. So thank you all for coming out. I see it in the chat. I see in the comments. I saw when I was putting this together. I had court this morning. I had 3 appearances of my own. And I thought I was all proud of myself because I had some clips put together, but they're already misbehaving. I make no promises, but there may even be another stream today because defendants just can't behave themselves. All right. Thanks a lot. I will see you all soon.